A new weapon that us defense attorneys have to fight the government.
We can extrapolate this to all sorts of other white-collar crimes, healthcare, securities fraud.
A big new change from the Supreme Court.
And the court in Seminelli essentially said, we need to police these prosecutors.
We have a real brand new tangible motion that can apply in so many cases.
Welcome to the Federal Verdict. My name is Marissel Descalzo, and I'm with Tarras and Descalzo.
Welcome, everyone. I'm David Tarras, and I'm a partner at the Rawson Law Firm. So today we are going to be talking about a new weapon that us defense attorneys have to fight the government, and this is specifically to fight them against their favorite tool, we could say, which is that nasty wire fraud statute that they love to sweep everyone up in, right?
That's right.
And there's been a big new change from the Supreme Court. Is that correct?
Absolutely.
Okay. Let's talk about it.
So last year, in around June, the Supreme Court unanimously held that this, it's often referred to as the right to control doctrine, cannot be used by a prosecutor to charge wire fraud. That is not wire fraud. And it's such an important issue because I'm sure everyone remembers the Varsity Blues case, right, where all these parents get charged because they're paying donations to schools for their kids to get accepted, and a lot of these people pled guilty. And then they go up on appeal, and after this case from the Supreme Court, Seminelli, is decided on, the First Circuit, where those Varsity Blues cases go to, say, you know what, this isn't a crime. We can't prosecute,
Which is huge.
Yes,
I mean, it's huge.
It's huge. It's incredible. And the court in Seminelli essentially said, we need to police these prosecutors. They can't just go around, continuing to expand the law. That's Congress's job. So it's actually a great decision for us. And we've already seen it apply in other places. And David, you want to tell us where we've seen just recently? I think it was a week ago.
Yeah, absolutely. And look, hot button area, which is securities fraud. Right? We're seeing more and more securities cases in the realm of cryptocurrency, right? All forms of security as digital assets grow and other forms as well. And so we just got this great ruling. And that was in the Southern District of Texas, Houston, I believe,
yes.
Right, the Houston division there, where it was a securities fraud matter. And this case, these charges, these allegations would have been brought countless times, right? And what happens in this case, and now we're fighting back, and we're getting the Supreme Court on our side, which is fantastic. What happens there is you have individuals who are through social media, Twitter, Instagram, etc., have followers, and in order to increase the stock prices of a specific security, are widely advertising the benefit of the security, the likelihood that it's going to substantially increase in value without really much of a basis to do so. And the facts and the actual statistics, the numbers regarding the security did not comport with the representations that these individuals were making. And they had a big social media following, and their followers, based on what they were told, what they saw on social media, decided to also invest in this security. And then what these guys did was that they then did a kind of a traditional pump and dump. Build up the security, sell it at its peak, inflate it, right, to a point where it's not really the value at all of what really exists. And this is a situation where the court, they indict them for securities fraud, and the court looks at this. The defense files motions, I believe 2 motions, to dismiss, where they're saying, look, we're not even going to get to the facts, but they have charged securities fraud here. They've charged wire fraud and under a theory, similar theories. And because of this change in the law, even taken everything as true, like in a motion to dismiss, as we know, you file it, you have to say, even if everything on the face of this charging document indictment is true, they have not alleged that a crime occurred. And they did so on the theory of this right to control, right, which is no longer being applied. So the defendants in this case filed a motion to dismiss, and the basis for their motion to dismiss is that this Supreme Court ruling in Simonelli, which was a wire fraud case, should also apply, and the court did apply it to securities fraud, which greatly expands the weapons that we have in fraud cases across the board. Would you agree? And what do you think about that?
Absolutely, and I just want to add that the one key distinguishing factor in this case in Houston is that the individuals that were promoting this stock had no benefit directly from the company. Their only benefit or connection to the company is that they own the stock.
Right.
And they were going to profit if the stock went up in price, but they weren't owners of the company, they weren't executives of the company, they were just shareholders. And the court found that was a reason to distinguish them, that they could not, under this theory that comes from the Supreme Court case, that they could not be charged with securities fraud. And the reason that this is so important is because we can extrapolate this to all sorts of other white-collar crimes, healthcare, securities fraud, wire fraud, of course, tax cases. And I think that it really is going to finally put a stop to the government who keeps trying to expand the law and push past what the law is, pursuant to a Congress who has the right to write the law.
Absolutely.
And the government's always trying to push that boundary. And I think that this is a hard stop. It doesn't mean that the government's not going to keep trying, but we need to, armed with this new tool, we can actually fight back. And now we know that judges are listening, like the judges in New York, the judges in Boston. Now we have a judge in Houston. And so, hopefully this is going to spread like wildfire.
Yeah, absolutely. And when we have a real brand new tangible motion that can apply in so many cases.
Absolutely.
Right? And judges, whether they go our way or not, the law is going to change, right? We have to file these motions. We're going to file these motions, and we're going to try them in as many cases as it applies to. Keep pushing those limits.
Absolutely.
Yep.
Well, thank you for joining us on The Federal Verdict.
Thanks. Stay tuned for upcoming episodes of The Federal Verdict. I'm David Tarras at the Rawson Law Firm.
And I'm Marissel Descalzo at Taché, Bronis, and Descalzo.